You ever been annoyed by a rule from your homeowners association? I think we all have. But what if that little annoyance snowballed into a huge, multi-year legal battle? Well, today we're going to break down a fascinating case out of Arizona where a single signpost did exactly that. And believe me, this story reveals some pretty surprising truths about community rules, what fairness actually means, and, how the law really works. So let's dive in. So let's just cut right to the chase with the big question this whole case raises. Can your HOA, the one you pay dues to, legally stop you from using property that you technically co-own? I mean, your gut reaction is probably, no way, that's my property too. But the legal reality? Oh, it is way more complicated than you'd think. All right, so our story begins at the Sierra Foothills Condominium, which is a commercial complex in Arizona. Now, the thing that sparked this whole legal firestorm wasn't some crazy party or a parking feud. Nope, it was something way more ordinary. A simple advertising sign. Okay, so here's the physical setup, and it's super important. You've got two buildings, both filled with businesses. But out front, there's only one of those big shared monument signs for everyone to advertise on. And the kicker? It only has 5 spots. You can already see where this is going, right? A classic case of not enough to go around. Now, this right here is the absolute heart of the problem. You had Building A, which was sitting pretty. It had direct street frontage, so any signs on the building itself were super visible to passing traffic. But then you have Building B. It was set way back, kind of hidden from the road. For those businesses, getting a spot on that shared sign wasn't just a nice to have. It was basically a lifeline. So the HOA board looks at this pretty clear imbalance and decides to make a really bold move. On June 10, 2020, they pass a brand new rule. All 5 spots on that monument sign, they were now reserved exclusively for the businesses in the less visible Building B. And that is the moment the legal battle officially kicked off. As you can imagine, a business owner from Building A, a guy named Keith Smith, saw this and thought it was completely out of line. He's thinking, hey, I'm a co-owner of this property. I have a right to use that sign too. So he files a legal petition against the HOA, and his first big argument was simple. This new rule is totally discriminatory. His entire argument really hung on this one key piece of evidence, the association's own rulebook. Their covenants, conditions, and restrictions, or CC&Rs. He pointed right to Section 7.1c, which says that the board's rules shall not unreasonably discriminate among owners. And for Mr. Smith, a rule that completely bans an entire building from using a shared sign was, well, the very definition of unreasonable discrimination. But this is where things get into the nitty-gritty legal weeds. Mr. Smith also pointed to another section, 6.26a, that seemed to say rules have to apply to all owners, period. But the judge spotted something crucial. That apply to all rule, it specifically said it only applied to regulations made under Article 6 of the bylaws. The sign rule, however, was made under the authority of Article 7. It seems like a tiny, tiny detail, but in law, those details are everything. Now, Mr. Smith wasn't done. He had a second major argument, and this one wasn't about the rule itself, but about how the rule was made. He claimed the HOA board totally violated Arizona's open meeting law by basically making their decision in secret, behind closed doors, before the public meeting even started. And you can really feel his frustration in this quote from his petition. He was convinced that the board members had already talked it all out over email. He claimed that when the issue came up in the meeting, the president just called for a vote with no real discussion. To him, this was proof positive that the public meeting was just for show. It was pure theater. But what the board members said in court painted a very, very different picture. They testified that they didn't just rush to a vote. In fact, they debated the sign rule for a full 90 minutes during that open meeting. And crucially, they gave Mr. Smith himself 20 of those minutes to stand up and make his case. That directly contradicts his claim that he was never heard. So, okay, you've got these two big arguments on the table. The rule is unfair, and the meeting was a sham. The case goes before an administrative law judge, and on November 16, 2020, the very first decision gets handed down. And the judge dismissed Mr. Smith's petition on every single point. The reasoning was pretty straightforward. First, the judge said the rule was actually reasonable. Why? Because the physical differences between the buildings made it a logical solution. Second, that anti-discrimination rule Mr. Smith found, the judge agreed it didn't apply to this type of rule. And finally, on the secret meeting claim, Mr. Smith had no proof, no emails, nothing, just his feeling, which wasn't enough to counter the testimony that a long public discussion actually happened. But hold on, the story doesn't end there. Mr. Smith was absolutely convinced the judge had made some serious legal and factual mistakes. So he filed for a rehearing, basically demanding a second look at the whole case. Well, the rehearing failed too, and this part really highlights another key legal lesson. The judge's core thinking didn't change. But critically, Mr. Smith tried to bring in new arguments and even new evidence. He said he now had an email that was proof of secret communication. Here's the big takeaway from that. You can't do that. The legal process isn't a do-over. You have to bring all your evidence and all your arguments to the table the first time around. So this brings us to the final outcome, and honestly, the most important lesson from this whole saga. It's a tough pill to swallow, but it's true. In the legal system, feeling like you're right, or even having a really strong moral argument, just isn't enough to actually win your case. Ultimately, this whole thing came down to one fundamental legal concept: the burden of proof. See, in a civil case like this, the person who files the complaint, in this case, Mr. Smith, has the job of proving their claims are true. The standard is called a preponderance of the evidence, which is a fancy way of saying you have to show that your version of events is more likely than not the correct one.
And that right there is exactly where this case fell apart for him. On June 3, 2021, the judge dismissed the petition for the final time. It wasn't that the judge decided the HOA was perfect. It was that Mr. Smith just couldn't provide enough convincing evidence to meet his burden and prove that they had actually broken the law or their own rules.
So we'll leave you with this question to think about. This whole case is such a powerful reminder that in any formal dispute, whether it's with an HOA, your boss, anyone, the question that wins isn't just, am I right? It's, can I prove it? Because that's the real difference between having a grievance and having a case. And it's definitely something to remember the next time you're glancing through your own community's rulebook.